Okay.
Morning, Your Honor.
Good morning, everyone.
Good morning, Judge.
Good morning. Good morning. All right. Do we have everyone we need? We got everybody
Believe so,
waiting on.
Judge.
Okay. Very well. All right. We are here on case 24CV004231. It is kind of one of the last cases that we have left. We do have some a couple of cases with represented litigants, but I believe this is one of the last cases we have left that is likely a trial. Um, so for the plaintiff, who do we have for the plaintiff?
Yes, Your Honor. Blake Fluvog and Tony Petroza are present for the plaintiff today.
All right, Attorney Fluvog, do you have the conflict for next week?
That's me, Judge. This
Okay.
is this is Andrew Horowitz, and I just got the email about 5 minutes before I sent alerted the court from the Gwinnett County staff attorney that I'm being called on Tuesday, and that's an action that was filed in June of 2023.
Okay. So where does that put you with us starting Monday?
Well, this is weird. I've never had this. I've only been had conflicts when both start on the same day. I mean, the calendar it begins on Monday, but the court in Gwinnett asked us to try our case on Tuesday. So, and I defer to the court completely on this. This is just uncharted territory. If I'm being summoned to appear there, can a conflict be created the same week in a case if one judge says I'm starting at 8:30 in the morning on Monday morning and the other one says 9 o'clock, do I have to show up to the one at the newer case at 8:30 and the older one at 9? I really don't know. I have no idea. So I defer to you and Judge Brown in Gwinnett County as to that. But the way I read the conflict rules, um, the older case does prevail. And so unless Your Honor tells me to show up to try a case and, try the case on Monday, then I was planning on appearing Tuesday morning in Gwinnett County for that trial. But
Okay.
again, I defer to you,
Okay.
Judge, completely.
Attorney Fluvog.
Yes, Your Honor. I think our discussion today can help sort out this conflict. So this case was actually originally filed in Judge Morrison's court in Fulton State Court in March of 2022. This is a October of 2021 motor vehicle collision. So in our opinion, Your Honor, this is actually the older case. And then we go to Mr. Horowitz's conflict letter. Obviously, it was deficient because he did not send one when he received notice of both of these trial calendars. So there is not prompt written notice as required by Uniform Superior Court Rule 17.1, paragraph capital B. I think we should also be asking whether he has mediated the case in Gwinnett. From my experience in Judge Brown's courtroom, they're not going to summon a bunch of jurors unless the parties have attempted to resolve the case between themselves through mediation. But yeah, just a little bit more clarity on the case in Judge Morrison's court. We filed it in March of 2022. It was dismissed by the court in October of 2023. Neither party dismissed this case without prejudice. And I think Mr. Lawley is on this call as well, and he can attest to the fact that our case was dismissed because our pretrial order was filed 5 minutes late on a Friday. We showed up Monday morning and the case was dismissed without prejudice. I will say nothing bad about Judge Morrison. I respect that bench, and it's been a pleasure serving in her courtroom for some time now. For the last 10 or 11 years, I've tried cases in there. So, but yeah, I mean, we're ready to go, Your Honor. I think this conflict can be worked out with a little bit of communication between your chambers and Judge Brown's chambers so that we can call a jury in your courtroom on Monday morning, 9 a.m.
Judge, if I might just respond very,
Yeah.
very briefly, as Your Honor knows, once, and, I don't recall when plaintiff submitted his pretrial and got dismissed, but when an action's refiled or renewed in a different court, it's a de novo action. So, it starts the clock over again. And I don't think there's any exception under the rules, under the Superior Court rules for renewed or refiled actions. It's de novo. That's well-established law. So if that's the issue, then I'd respectfully submit that I'm required to show up Tuesday morning in Gwinnett County for that trial, if that's the issue. As far as mediation, not that that really has any effect on the Superior Court rule. Yes, we have mediated that case, but also putting that aside, and I don't know if Your Honor noticed, I think I've been on about 10 trial calendars, this month, and I've had to submit the most complex and many of them were overlapping, very complex conflict notices. And that other one, it wasn't even on my radar. I didn't think we were going to get called because the plaintiff's attorney announced to the court that he asked to have it postponed. So for whatever reason, it wasn't added. As soon as I got notified yesterday afternoon that we were being summoned on Tuesday, I immediately let the court know. And that does not unwind the conflict that it has now created. And I promptly let the court know, to the extent that, I didn't notify the court as soon as I got the notice 20 days earlier, that we were on the trial calendar. I apologize, but this is a de novo action here. So I don't think the fact it was a refiled suit really has any bearing on the conflict issue. But that's my piece.
Understood. I'm kind of looking at the what the rule 17.1 method of resolution. And I will reach out to the Gwinnett County Court. You all said it's Judge Brown.
Yes,
Um,
Miss Judge Carla Brown. And I'd
okay.
be happy to forward to the court the email that I got yesterday. If Your Honor would like that too, I could send it to
Yeah,
Ms.
please send it to
Yes.
Attorney McGinnis.
I
Yes.
certainly will. I can do that right now. Yes.
And I guess I'll have this discussion with Judge Brown. I'm looking at 17.1B, when an attorney is scheduled for a day certain, and we're Monday, Judge Brown is Tuesday. If you report to me Monday and I don't release you, then I don't know that you'll be able to report to Judge Brown on Tuesday. For that, like I said, I will have that conversation with Judge Brown. Her case, at least the number it seems to be filed, the case number that before each court, her case seems to be older. Judge Brown's case seems to be older. But if Tuesday, Monday, I might win. I might win the conflict issue, but I'll have that conversation with Judge Brown, because I can see me saying that, then Judge Brown changes and calls you in Monday morning.
I just don't want to run afoul of either.
Right, I
judge.
understand. I understand. All right, so there is that conflict issue out there, and what I'm trying to prevent is from people working over the weekend and having witnesses here and it not going forward, that becomes frustrating. As a 20-year trial lawyer, I worked plenty of weekends and I got there Monday morning and for whatever reason it didn't happen. So I try to prevent lawyers from doing that. But sometimes from time to time things happen. All right, let's discuss the motions in limine, the supplemental motions in limine, and the second supplemental motions in limines that have been filed. Um, Attorney Fluog, do you want to start with plaintiff's motions?
Yes, Your Honor.
And I show the plaintiff filed an original motion in limine in October of 2024, and then a supplemental January 21st of 2025.
Yes, Your Honor. I believe it's 12 total motions in limine. No, 10 total.
10. I have 10. Okay. All right. Good.
But if Your Honor will allow me, I think that the better starting point for this conversation might be the jury instruction as it relates to spoliation, Your Honor.
Okay.
Obviously, plaintiff has worked very hard to get this decision overturned or to persuade you to overturn. But
And
that's
Judge,
not
I don't mean to interrupt, Mr. Fluvog. If we're going to argue that our motion in limine as to apply the evidentiary presumption to limit certain evidence, that would be our motion, and not plaintiff's motion to argue first.
Well, I'm going to hear from Mr. Fluog, and of course, everyone will get a chance to reply. You may continue, sir.
Thank you, Your Honor. So what we found out today, Your Honor, and I should have looked at this a little more closely, but I have been asking from the affidavit for Ms. Cantrell for some time. Most recently in Dr. Ziegler's deposition, Mr. Lawley attempted to use the affidavit from Ms. Cantrell during his cross-examination of Dr. Ziegler. At that point, we went off record so that Mr. Lawley could actually find the affidavit and share his screen so that we could all know what he was looking at, but he said that he could not find it. I did find it today in defendant's original motion. And we have several issues with this affidavit, Your Honor. The entire motion is based on this affidavit that has not been entered into evidence, has not been produced to me with the intention of it being admitted into evidence. And further, the affidavit was not made in the course of Ms. Cantrell's employment as a records custodian. If you'll allow me, Your Honor, I can share my screen with you.
So I'm not sure what motion we're talking about at this point.
Well, we're talking about the original spoliation motion that defendants filed. You ordered and granted that, Your Honor. We filed a motion for reconsideration and a motion to vacate. So this is more of a discussion about the procedure of the jury instruction that's going to be given. That you
Okay, and that's hold on, sir. Hold on, Mr. Schwarzowitz. And that's fine, and we can have that discussion, but now is not the time to have that discussion. I'm here today to talk about you all's motions and limines. I do have, 11 that I could probably push back to 11:30. So I got time to discuss the motion and limine this morning. So if we could please focus on those.
Yes, Your Honor. Of course. Let me switch down to okay. All right, our first motion in limine, Your Honor, is essentially collateral source, if you want to give it a title. So obviously, this is longstanding Georgia law that any evidence of insurance or any payments by a third party is not admissible in a trial. And that's our first motion in limine. My client was actually received workers' compensation benefits because he was in the course of his employment at the time of the subject collision. And so we would request that any mention of his workers' compensation benefits or workers' compensation or anything of the like would be excluded from testimony, evidence, everything during voir dire, all the way up until a verdict is rendered.
Okay, and you can go through them. Let me hear what you have to say about your motions, please.
Okay. So do you want to allow Mr. Horowitz to respond? I'm done with arguing number one, Your Honor.
No, I'll get his response after you've completed your presentation.
Okay. Of all of my motions in limine, is that accurate?
Yes, sir.
Thank you, Your Honor.
And if there are any, objections or conflicts, we can focus in on those.
Okay. Well, I think that is a big sticking point here, Your Honor, because defendants have also filed a motion in limine on this exact subject, saying that plaintiffs should only be able to tender evidence of medical bills up to the fee schedule under his workers' compensation insurance policy. So I think there will be an objection there. The other part of this motion is that any mention of how plaintiff got to his doctors, how he was referred to those doctors is completely irrelevant. And then it also opens the door to workers' compensation. So the law is, yes, if there is testimony, which there is in this case, plaintiff's deposition, page 58, line 8 through 12, he mentions that his lawyer helped him get to the TBI Diagnostic Testing Center. And so, if you do allow that testimony in, Your Honor, then we have the opportunity to explain. That's the law. And let me see if I can find what that site is. I think the site is in my brief, Your Honor. But yeah, essentially, if we had to explain that, we would go into, well, his workers' compensation benefits and his workers' compensation, the board or whoever it was that was making decisions on his care plan, they denied his request to receive traumatic brain injury testing. And so therefore we had to help him get to a center that could, because his neurologist was recommending that this test be completed. So for him to follow the care plan of his neurologist, that we had to help him get to a testing center. So it all just surrounds workers' compensation and collateral source, Your Honor. You want me to go to number two now?
Yes, sir, please.
Okay. This is no mention shall be made of the time or circumstances under which plaintiff employed their attorneys. There's no relevance to it. We cite 24-5-501A2 and 24-4-402. Yeah, it's really just to distract from the true issues, Your Honor. And I think that he hired us much later into the process anyways. So I'm not sure if that's even a position that defendants are going to be taking at trial or a strategy. Number three is what we're just asking the court to prohibit any discussion, opening, closing, cross-examination, any witnesses about how Morgan & Morgan advertises, how big of a firm we are. Obviously, we're going to be qualified in voir dire, but what we've seen recently, Your Honor, is just that, that counsels are making claims, especially in closing statement, that this is what Morgan & Morgan does. They get involved in cases and they, make the medical expenses way more than what they would have been if the attorney was not involved. This is clearly irrelevant, prejudicial, and certainly would have an effect on the jury's deliberations. I don't think there's any evidence for number 4, Your Honor. I'll wait and see if defendants have any response to that before I withdraw it, but I'm just not seeing. This is documents used for impeachment under Barone. Yeah, I'm not seeing any evidence in the record or in the proposed exhibits that's going to be applicable to this case, Your Honor, but I'll wait to hear from defendants on number 4 to decide what we want to do. My client, number 5, is about prior subsequent claims. He did have a couple of previous workers' compensation claims on his knee and I believe his hand. So that it's just completely irrelevant to the issues in this case, Your Honor. Would only be used to say that, that this plaintiff is a career client or somebody who likes to make claims throughout their life. So we would ask that any evidence to that effect would be excluded. Okay, number 6, we cite Honeycutt versus Honeycutt. This is about alternative causation arguments from opposing counsel, Your Honor. There is no evidence in the record that he had any prior conditions that would have affected the injuries that we are claiming in this lawsuit, other than some low back pain that he treated with Dr. Ziegler for anywhere from 3 to 10 years ago is the evidence in the record, Your Honor. There are no actual records that I have been provided, and I will say that, take that with a grain of salt, Your Honor. We have already sent defendants our proposed exhibits and are working through objections on those. We may need your assistance working through those, but I have not received any proposed exhibits from defendants, but I have been promised that I will receive them well in advance of trial Monday. So yeah, that is what number was that?
6.
Number 6, Your Honor. So we cite Honeycutt versus Honeycutt. They don't have any expert witnesses that have been disclosed. So, just throwing this out there is, Mr. Pitts has prior low back pain in his past. It's just, it's going to distract the jury from the true issues. They don't have any records or experts to support it. So we would request that any arguments to that effect would be excluded, Your Honor. I don't think my client has any prior criminal convictions, at least that would be admissible. Again, I would wait to hear from defendants before I withdraw that one. That would be number 7. Number 8, this is another issue that we see over and over, Your Honor, in the trials that we're having in the last couple of years, is that, defendants and defense counsel gets very clever about, who has to pay the verdict in closing arguments and opening statements. Poor old B&D Concrete Cutting Incorporated and poor old Billy Irelan are going to have to pay the judgment. So we brought that up to your attention, Your Honor, just so that the court is hyper focused on those issues, and we will object as required by law immediately and move for a mistrial. I do want to put on the record that if we do move for a mistrial, this is not a sitting on the fence type of thing. That plaintiff is going to move for a mistrial and will desire a mistrial if defense lawyers make any comment to that effect. The flip side of that, Your Honor, is that the conduct of defendants and defense counsel could be sanctionable if it appears that they're doing that intentionally to create it. If the trial looks like it's not going in their way, we had this happen in Clark County last May, and I'm not going to name names, but I was in front of Judge Hope, and he did admonish the lawyer in front of the jury. He did not grant a mistrial, but we ended up getting a positive verdict on that, so it was not appealed, Your Honor. So yeah, we just want you to be hyper focused on number 8, and we will object accordingly if those issues do come up. And then we've already been talking about this, Your Honor, but number 9 is just there really shouldn't be any mention of the prior litigation in Judge Morrison's court. As we see it, this is one continuous litigation. The only reasonable explanation I can see for making that argument for defense counsel is just that, maybe the plaintiff's claims weren't that good to start with, and therefore they were dismissed in the first case, and now they are jumping through a procedural loophole to refile. Obviously, that kind of argument would be severely prejudicial, Your Honor, and would not be probative at all. So we would just, and it's not relevant too. We cite to relevance 401, Your Honor. Number 10, we're just moving for defendants dash camera footage to be excluded from any type of evidence. We do not intend to admit it as evidence, Your Honor, and breach of the duty in this case has already been admitted, so there's no reason for the jury to waste its time by watching the dash camera footage.
All right, thank you. Understood. Let me hear from defense. Anything as relates to plaintiff's motion in limine, and let me say this before we go into it. A lot of the motions in limine on both sides are general statements of the law. We will try the case according to the current state of the law and the rules of evidence. I don't want to prejudge anything or presuppose what someone may say. If you all, during the course of the trial, believe that a rule of evidence or a piece of law has been violated, please make your objection. But so with that, I will hear from the defense as it relates to plaintiff's motions limit. Attorney Horwitz. And you're muted, Attorney Horwitz.
I'm so sorry about that. Thank you, Judge. And for what it's worth, in my 30 plus years now, I've never prompted a mistrial. I've been in trials where the plaintiff has prompted them for various reasons, but I've never done so. I don't plan to do so in front of Your Honor. As far as the first motion in limine, Judge, the workers' comp fee schedule, I agree that to that motion to an extent. I don't think workers' comp or any insurance in this case should be mentioned by either side. That's a starting point. We agree with that completely, and I think that applies to the plaintiff as well. And I respectfully ask that be applied mutually. As far as the fee schedule issue is concerned, though, and the collateral source issue, I get the collateral source rule, Judge, and I understand it. We should not benefit from, if there's private health insurance, a negotiated rate between the health insurance carrier and the medical provider. If the medical provider charges $20,000, the health insurance carrier negotiates it down to $5,000. The plaintiff in that situation would still have some additional exposure on top of the $5,000, but and might have to pay a portion of that still, but that benefit goes to the plaintiff because he's paying or she's paying the health insurance premium. And under the collateral source rule, Judge, that difference is inadmissible. The set off, the write off, the negotiation is inadmissible, and the plaintiff can recover the full amount, the retail bill. The defendant in that circumstance, Your Honor, can challenge the reasonableness of the bill. Let's say it's a plaintiff's attorney who sent a client to a certain type of doctor who treated on a lien or a letter of protection and inflated the bill 10 times, 30 times, as I've seen sometimes, well, then you can challenge that. But you can't talk about the negotiation between any health insurance company and the medical provider. That's collateral source. Workers' comp, Judge, as your honor knows, is different. Workers' comp it's governed by a fee schedule. The fee schedule is like a price fixed menu. It says doctors in Georgia, medical providers in Georgia, if you treat an injured worker who's injured in the course of his or her employment and who's covered by workers' comp, you are governed by this fee schedule. Here are the prices you can charge. And you may not seek to collect anything, not a penny, from the injured worker. So if an injured worker is sent to a hospital or an orthopedist or any other doctor, and that doctor says, well, my normal fee is for this, this sort of service is $10,000, but the fee schedule says, no, you can only charge $1,500 for that. The doctor, under the statute, may not charge more than what the fee schedule allows. Anything above the fee schedule is an illegal bill, and the plaintiff is never exposed to that any difference. It's an illegal, improper bill at the moment that it is sent to the workers' comp carrier. And in that case, Judge, there's no benefit being gotten by either side through a negotiated rate or a negotiated payment. This amount is set in stone. It's illusory and it's unfair. Now, the policy, again, under a typical collateral source situation, is that the defendant shouldn't be able to benefit where the doctor charges a reasonable rate that he or she is entitled to charge. It just might get negotiated down by the health insurance company. This is not that situation. The doctor, medical provider may, when they charge the the injured worker, they may not charge more than the fee schedule. And we cited in our motion in limine on this, a judge in the Middle District who granted a similar motion in limine on this and prohibited the plaintiff from seeking to introduce more than what the fee schedule allowed. Now, we're not going to mention workers' comp, and that judge said you can't talk about insurance, but by the same token, it would be unfair and it would allow the plaintiff to seek a windfall that he was never entitled to recover in this situation by blackboarding or even mentioning retail bills that violated Georgia law, a Georgia fee schedule statute that they were never allowed to charge in the first place. So that's our response to that. This is unsettled law. Admittedly, Judge, the Court of Appeals has never weighed in on this issue. The only court, as far as I can tell, that has the only the trial court order I've seen has been from the Middle District, and they have interpreted the statute the exact same way. But quite frankly, just to the extent that another trial judge, other trial judges in the state, and I've seen them, and I've been in cases where they've just simply denied the motion, like Judge Morrison has, without really an explanation. It has not been resolved by the appellate courts. And so I'd respectfully submit, Judge, I mean, this is an issue that it really needs to be resolved by the appellate courts. But in the meantime, if Your Honor looks at the fee schedule statute that we cited in our motion, it will see the medical providers may not charge more than what the fee schedule permits, and they may not seek to recover 1 penny more against the injured worker, in this case, Mr. Pitts. Number two.
I guess, let me ask you
Yes,
a question
Sure.
on that. And I think we in conjunction with plaintiffs, one, we've jumped to defendants, second supplemental. My question is, a lot of things are violations of the law. But then the question becomes, what's the remedy for the violation of the law? If a medical professional charges more than the workers' compensation fee schedule, which you said they're not allowed to do, if someone does that, what's the remedy? Does workers' compensation not pay it? What's the remedy?
The remedy, judges, and this is exactly what happened here, because Mr. Pitts, the workers' comp payments for his treatment is significantly lower. What the medical providers were paid per the fee schedule is much lower. The remedy, judge, is to prohibit the plaintiff from seeking to recover special damages that his doctors were never permitted under the fee schedule to charge, which were illegal bills that violated the statute. So the remedy is, plaintiff, you can recover for that treatment. You can recover for that treatment. But if your doctor submitted an illegal bill for $10,000 when workers' comp, under the fee schedule has deemed that the only lawful charge is $1,000, you can recover for that bill, but you're limited to what the statute says you are permitted to recover. That's the remedy, judge.
Okay. All right.
Your
What
Honor,
else
if
do you?
I may
And
respond.
Let me
I,
hear him as to the rest of the plaintiff's motions. You'll get another chance, Mr. Fluba.
and number two, judge, that has to do with referrals to doctors. I agree. We're not going to. We have no intention of eliciting any testimony about any referrals to doctors that the workers' comp carriers referred him to, but any ones that, on top of that, if the plaintiff is trying to say manufacture, I don't know, a TBI claim, and workers' comp said, nah, there's no causal relationship, and the plaintiff's attorney refers the client to a friendly medical provider who treats for that, and that medical provider has treated on a lien, taking a pecuniary interest in the case, then the referral to the doctor under Georgia law, that then makes it makes it a relevant issue, and it shows bias by the medical provider, that they're being referred by plaintiff's counsel. They're treating on a lien. They're taking a financial stake in the litigation, and all of that should be fair game. If
Your
it's a
Honor, if I
referral,
may, very quickly, I would just
I don't
add that
remember interrupting Mr. Flubach, Judge, during his
I
argument.
do remember you interrupting him. But we
Well,
all y'all we can't do that. We're gonna have a trial, and we can't talk in and out of people. Attorney Horwich, you may continue.
okay. Number three, Judge, is but the gist of number two is it under certain circumstances it can show bias.
Do you think that's one of these? This case is one of those circumstances.
Yeah, there's one. This TBI doctor apparently treated on a lien or a letter of protection and has a financial interest. So that evidence, I'd say, Judge, would be fair game.
Understood.
Number three, Judge, the attorney adds, the only time that could possibly come up is voir dire. Is anyone familiar with them? Has anyone seen their advertisements? Is anyone influenced by that? But as far as using it in closing argument in a disparaging manner, Judge, that's not our style. Number four, let me see. I wrote down impeachment, and I don't remember. Oh,
these are documents that.
Yeah, these are Judge, if we can impeach using I mean, Judge, I have to look at this Barone versus Law case again. But outside the presence, I don't want to slow this case up, Judge. If there's a document that we've produced in discovery, or that the plaintiff has in his possession, I'd respectfully submit that we can show it to the plaintiff and cross-examine him without having to send the jury out every time that we want to impeach him with his any prior any record. But I would defer to the court as to how, under the circumstances. I mean, I'll certainly show any records before I use them to impeach the plaintiff's counsel. If there's an objection, he can, I suppose, can object. Number 4 or 5, rather. Okay, prior. Okay, I can't understand my own notes. Hold on one second. We're making reference to prior subsequent claims or lawsuits. I agree with Mr. Fluvog. If Mr. Pitts is not seeking any damages relating to his knee, and he had a prior workers' comp claim relating to his knee, we're not going to bring it up. The only evidence we would introduce regarding any claims would be any that are relevant to this case involving neck, back, head, elbow, things of that nature. So, we don't intend to just talk about claims you file for other parts of his body. We wouldn't do that. Number 6, this one I thought was particularly interesting, and this sort of ties in, and I'm going to reserve my argument, but prior condition alternate causation theories. Mr. Fluvog says, and I wrote this down, quote, that we do not have any records showing the plaintiff's pre-accident records. We don't have any records showing that he had any of the same sorts of conditions that he's trying to attribute to the accident. I found that one to be, astounding, Judge, in light of the court's spoliation sanctions order. We don't have the pre-accident medical records, Judge, because the plaintiff concealed his chiropractor's identity from us. And by the time that he finally disclosed his identity 7 or 8 months later, those records were not available. And had he identified the chiropractor to us timely, when we asked him specifically in our interrogatories, have you been to a chiropractor before? And he didn't identify him, Mr. Ziegler. If he had identified him, we would have been able to get those records. So I found it, remarkable. So the court has granted our spoliation sanctions motion, has imposed an adverse evidentiary presumption that those records, if preserved, would have been harmful to the plaintiff. Now, what that means, Judge, is, they would have shown the types of treatment that a chiropractor treats for, and it would have been harmful if preserved to the plaintiff. What does that mean? What do chiropractors treat for? Well, they treat for head injuries. They treat for neck injuries. They treat for back injuries. They even treat, according to plaintiff's own doctors, they treat for carpal and ulnar tunnel syndrome issues. All the types of things that the plaintiff is trying to attribute to our accident. The adverse presumption is that those records, if preserved, would have shown those sorts of conditions. What else did chiropractors do? They take x-rays. They have this particular chiropractor has another chiropractor in his practice he refers to. He refers to other medical doctors. His records, if preserved, would have shown all those things. And there is an adverse evidentiary presumption on that. So for Mr. Fluvog to say that we don't have any records, so we can't argue alternative causation, is really, again, astounding. It just, and this is again, and I'll argue the other motion, but it again brushes under the rug the whole order that the court entered a few months ago on the spoliation sanctions motion. Plaintiff is litigating this case as if that motion were never, or if that order were never entered by the court. Ignoring it in this case. But I'll move on. On that one, number 7, convictions that he's had. We're not aware of any prior convictions, and if we are aware of any, and they're felonies or crimes of moral turpitude, we can only introduce certified copies to impeach, but we're not aware of any. Number 8, Judge, had to do with personal financial responsibility, essentially. And that's one that we agree with. And it should go both ways. The plaintiff shouldn't be talking about his, how this has affected him financially either. But I've never stood up in front of a jury and said, woe to my poor client who has to pay a judgment. I think that, quite honestly, would be improper and would warrant a mistrial. We're not going to do that. We can introduce who they are, but we certainly are not going to talk about personal financial responsibility. Number 9, let's see, this I wrote down prior litigation. Oh, yeah, Judge, we don't plan to talk about his dismissal and the litigation. Now, if there's some testimony he gave in the prior litigation, we might need to use that, say to impeach the plaintiff's credibility, but we're not going to talk about the fact that it was dismissed by the court. And last, Judge, number 10 is the video. Now, yes, we have admitted fault. There's no question about that. But Judge, the plaintiff, the video is relevant to causation and to impeach. The plaintiff in this case has testified that he was completely stopped when he was struck from behind. If you're stopped when you get hit, then the force of the impact is obviously more significant than if you're moving at the time, which is what the video would show. So, Judge, I'd respectfully submit that under those circumstances, the video has relevance to causation, the force of the impact, to impeach the plaintiff's account of how this happened, and other things, other testimony he's given that is inconsistent with what the actual video shows. And that's all of them, Judge.
Thank you. Thank you.
Thank you.
I will hear from the plaintiff. Your motion, you get last word on your motion. Any response?
Okay, Your Honor, just first on the record, plaintiff is requesting that we receive an order after this that we can refer to during trial with your decisions about these, but that's just an administrative issue. Your Honor, I do want to put this on the record as well, because I think I've only done it one other time in 10 years, but plaintiff is moving for sanctions on defense counsel based on this renewed motion surrounding collateral source and workers' compensation. Your Honor, this is res judicata. This is the definition of res judicata. Your Honor, it's the 3 elements of res judicata are the identity of the parties. They're identical. The cause of action, it's an identical cause of action, Your Honor, and a competent court with proper jurisdiction. This was Judge Morrison's courtroom. I think y'all are seated in the same building right now, Your Honor. So I don't think either party is going to argue that that wasn't a competent issue. It's a novel issue for a reason, Your Honor. There's no law on it because the law is well settled. The only law they've cited to is a Middle District of Georgia order that I think that's certainly persuasive, Your Honor, but all the case law and statutes point to collateral source that workers' comp cannot, including the fee schedule, cannot be mentioned to the jury. We actually have the bills. The bills have been entered into evidence, I believe, or at least they're going to be proposed to be admitted into evidence. They've been traded throughout discovery. We sent our exhibits back in November. We sent a new link. So, the bills are what they are. I guess we would have to come up with, the fee schedule or get into the workers' comp. It just opens the door to workers' compensation in general. We cited Candler Hospital, obviously, as the longest-standing collateral source rule in Georgia's 1997 Georgia Court of Appeals. I don't think he made this in oral arguments, but he attributed collateral source or workers' compensation to bankruptcy. Bankruptcy is completely different, Your Honor. This order would incentivize terrible things, Your Honor, in this state. It would encourage bankruptcy filings, actually. It would disincentivize workers' compensation claims. and workers' compensation is a third party insurer. Bankruptcy is the federal government. There's no third party there, Your Honor. We have a workers' compensation carrier. It's a Amerisure. And I'm trying to figure out the most respectful way to say this, but Mr. Horowitz has repeatedly said throughout his brief, and this goes for Mr. Lawley as well, throughout his brief and during oral arguments today, that the fee schedule, if the bill is above the fee schedule, then it is illegal. That is completely false, Your Honor. The fee schedule is a guideline. It says it right there in the workers' comp statute, in the OCGA. I'm trying to find it's Title 33, though, Your Honor, is the workers' comp. It's a guideline. They say if the bill is above the fee schedule, then it deserves peer review and mediation to determine the reasonableness. We don't have any information about what went on here in Mr. Pitts's case about was there a mediation? Did workers' compensation actually pay more than the payments described on the itemized bills, the certified bills, after they were actually paid? It no way makes that bill unlawful, Your Honor. I mean, workers' compensation statute calls it casualty insurance, defined as insurers. And then hotel equipment v. Liddell, that's 32 Georgia Ave 590. It's a 1924 case, I see, but that goes exactly to my point, Your Honor. This is settled law. Workers' compensation is insurance, and we cited that case in there, Your Honor. So as the court knows, orders are not law. And defense counsel is making a very, very clever argument, and I commend him for that. But I don't think that we're in a position to upend collateral source today, Your Honor. I think that's for the General Assembly and Governor Kemp to do, which I do believe that they're showing a lot of focus in that in this session. But this is not the proper venue for that, Your Honor. Oh, and this point too, Your Honor, he cites in his original motion and his refiled motion that all of plaintiff's treatment was under the workers' compensation program. I believe that opposing counsel knows that is false because we just discussed TBI Diagnostics, United Neurology. I don't have a list in front of me, but there are multiple providers who did not get paid by workers' compensation. So how are we supposed to differentiate that to the jury when we are, explaining that the fee schedule is actually the reasonable rate of the bill and not what's actually on the bill, Your Honor? Okay, and then he made this one point about that medical liens are just automatically admissible because they go to bias, Your Honor. That's not the law. Funding is certainly that the statement of law as it relates to medical funding companies. Sure, yes. I can't remember the name of the case, but that is that's settled law. But these orders go 50-50 is what I'm saying. They either it's up to the discretion of the court, Your Honor, if you're to allow evidence of United Neuro or TBI Diagnostic Center's letter of protection within their medical records to be admitted into evidence and taken back to the jury room during deliberations. We would argue against that, obviously, Your Honor. It's irrelevant how these doctors are paid. It's directly within collateral source again, Your Honor. And I don't know that defendants have submitted any evidence to show that these doctors do have a pecuniary interest in the case. I haven't seen it in any briefs or anything like that, Your Honor. I think that's all I had as to the workers' compensation, but I do just want to make sure that my motion for sanctions, attorney's fees for having to respond to this motion again, when Your Honor, as well as everybody in this hearing right now, knows the rules of res judicata, and this fits directly square within that, as well as, you know, the law is the law. Collateral source includes workers' compensation benefits. So I think this is just, you know, we're spinning our wheels on issues that we don't need to be spinning our wheels on, Your Honor. That's the position of plaintiff. For that particular, I think that we were going back to the Barone case. Your Honor, one way I think that we could clear that up is if they have records that they intend to impeach Mr. Pitts or any other witness with, is go ahead and send them to me now. I'm happy to review them and let them know about any potential objections that we have, so that we can clear up these objections and maybe come to some sort of stipulation about the evidence to be presented on cross-examination, Your Honor. Like I said, I've asked repeatedly throughout this litigation, as we've been on trial calendars in Your Honor's court, to review defendants' exhibits. We have received zero at this time, Your Honor. And Your Honor, do you want to go ahead and talk about the issues surrounding Dr. Ziegler and the alleged spoliation of evidence at this time?
Well, if we're done with your motions, I do want to say to both sides that plaintiff's motion 2 on the TBI doctor, the medical funding aspect, I am, everything else I understand. And not that I agree with you, but I understand your argument. I understand both sides' argument, and I have an idea about how I believe the law and the rules of evidence set up on that. But the second one, the doctor, and I will look at it. But if you all have any other any law or statutes for me to look at on that particular motion in limine plaintiff's motion number 2, please send that to Attorney McGinnis so that I can look more into that issue. That something I'm a little bit unfamiliar with. So if the lawyers can help me on where to find the proper and how to do the proper analysis on plaintiff's motion number 2.
Yes, Your Honor. I'll certainly send that to Ms. Rass McGinnis. What the law says essentially is that if Your Honor is inclined to allow that testimony to come in, that plaintiff's attorneys referred him to this TBI diagnostic testing, then we also get to explain why that had to happen. It can't just be, we can't be prevented from explaining why that happened. Well, we're going to have to get into workers' comp, Your Honor, to explain that referral to TBI diagnostics.
Okay. Well, if you all would get me something on it, so I'll make sure I understand the issue and
we will, Judge.
Okay. Let me turn to defendant's motions in limine. You all had 21 in your first, 2 in your supplemental, and then one I think that we've kind of discussed, your second supplemental regarding the workers' compensation fee schedule.
Yes, sir. Yes, sir.
Attorney Horowitz, I'll hear from you on any of your other motions that you want to hear.
I appreciate that, Judge. And because Mr. Flugfog brought up this res judicata issue in his rebuttal, I would just, before I moved on to our motion, just respectfully submit, Judge, res judicata applies to, you know, final determinations, final adjudications, not evidentiary issues. If there's a trial and one court makes a hearsay ruling, an evidentiary ruling in one case, and then the case gets dismissed and refiled in another court and tried in another court, the judge is perfectly able to reach its own decision on that. And I would refer, Your Honor, also to the U.S. Supreme Court case, Bobby versus Buys, and that's 556 U.S. 825. That's a 2009 case. And the court held, and I quote, judgment does not depend, if a judgment does not depend on a given determination, relitigation of that determination is not precluded, end quote, by the doctrines of res judicata or collateral estoppel. So that's what we're talking about. This is a refiled action. It's de novo. Your Honor is able to make your own evidentiary rulings, and there's been no adjudication on the merits. All right, and I'm going to move on to our supplemental motion first, if that's okay, since it's the meatiest one, I think. And that, Judge, is a motion in limine to prevent the plaintiff from introducing evidence that conflicts with the court's spoliation sanctions order in the plaintiff's response, and that is specifically to prevent him from introducing testimony from his chiropractor, Mr. Ziegler, that tries to fill in the gaps of what the spoliated chiropractic records would have shown and his treatment, as well as medical expert causation opinions that do not address the adverse evidentiary presumption and disregard it and do not lay a proper foundation for it, for those opinions in light of the court's order. Now, I just want to make it clear, Judge, because the plaintiff tried to couch our motion in limine as one for seeking clarification or reconsideration or expanding the court's spoliation sanctions order, and that's not the case at all. We embrace the court's order. We are just now asking the court to apply it, to apply the presumption, the adverse presumption created by the order to prevent the plaintiff from seeking to gain an advantage, in this case, from his own spoliation, which is improper. Now, again, I mentioned the underlying facts before, why we're here in the first place. The plaintiff concealed evidence, the identity of that chiropractor. We were unable to get his records because of that concealment, and the court in turn entered its order. Again, it ordered an adverse evidentiary presumption, and that, of course, means that if the evidence were preserved, it would have been harmful. That is, there is a presumption that if the chiropractic records were not spoliated, if he had not concealed the chiropractor's identity and precluded us from getting those records would have to be interpreted in the worst way against the plaintiff. That there were objective film studies that chiropractors typically take, in which Mr. Ziegler acknowledged he routinely does, showing the same levels of degeneration that in his neck and his back, and the same head complaints, and the same neck complaints, and the same low back complaints, the sorts of things that chiropractors treat for routinely. We have no way of refuting any testimony that might be filled in or attempted to try to fill in what was spoliated. Now, this is a rebuttable presumption, Judge. It's a rebuttable presumption, and we agree that the plaintiff can present evidence showing with credible, competent evidence that he did not have prior issues. How can you do that, Judge? How can you do that? And how can you do that in a way that is consistent with the court's spoliation sanctions order and where he doesn't gain an advantage? Well, I'll tell you a couple of examples. He could do that by identifying film studies from other doctors or testimony from other doctors who treated him in the years leading up to the accident. That's fair game. If he had an MRI study done at a hospital during the year before the accident, which shows that his neck and back and head were all squeaky clean and he had no issues, that is how he can rebut the testimony, or the presumption rather. He can rebut the presumption that the chiropractic evidence would be adverse to him in the worst way by introducing evidence that that we can challenge. We can look at the pre-accident film studies. We can cross-examine, a pre-accident treating doctor's testimony. We can do those things. We can look at the records that the pre-accident medical provider has generated and cross-examine him or her as to what he or she, elicited, what the studies they've done. We can do that, and that is fair to us, and it's fair to the plaintiff, and it doesn't enable him to gain an advantage. What can't the plaintiff do? Now, the overarching policy, Judge, in this state is that a party that spoliates evidence cannot profit by the spoliation. They can't put themselves in a better position because of the spoliation than they would have been had the evidence not been spoliated. You can't gain advantage by the missing evidence. Now, what's the authority, Judge? And we cited a bunch of cases in our briefs. The Court of Appeals has made it clear that a spoliating party cannot admit testimony or evidence as to what the missing evidence would have shown. I'd refer your honor to the Chapman case, which we cited. That's 220 Georgia Appeal 539. That's a 1996 case. It's been in existence for almost 30 years now. In that case, the court determined that the plaintiff could not introduce witness testimony about the spoliation. And the reason, Judge, and it's evident, is because the non-spoliating party, the other party, can't see the evidence. They can't inspect it. They can't test it. And it would be grossly unfair. And the result, Judge, the Chapman court noted that would result in trial by ambush. And in that case, Judge, the trial court did not prevent the plaintiff from trying to fill in the gaps of the missing evidence, and the Court of Appeals determined that was not the right course. Judge, there's a more recent Walmart case versus Lee, and that's 290 Georgia Appeal 541. In that case, Walmart did not preserve video that would have shown that depicted an assault in its parking lot. And that court, Judge, held that that Walmart could not elicit testimony as to what the video would have shown had it been preserved. There's no way to refute that testimony. And in that opinion, Judge, there's a little segment from the trial court's order that was affirmed, where the trial court wrote, quote, "Rather than listening to various witnesses attempt to recollect on the stand events that took place in 2001, the jury would have been able to watch them exactly as they happened," end quote. In other words, the spoliating party can't testify, elicit testimony. This is what the video would have shown had we not spoliated it, because that would give them an advantage. And that's exactly what the plaintiff is trying to do in this case. And they're trying to gain an advantage through their spoliation in two distinct ways. One, through the testimony of the chiropractor, Mr. Ziegler. He was recently examined. He treats thousands of patients. And he tried to fill in the gap. This is what I remember treating him for, and this is what I didn't treat him for. I remember. But he acknowledged how many patients he's treated. His recollection of Mr. Pitts was at odds with Mr. Pitts' own recollection. But the bottom line, Judge, is there's no way for us to challenge Mr. Ziegler, the chiropractor's testimony. The only way that we could testify or rebut his testimony would be through the records themselves, the same records that the plaintiff prevented us from getting. We can't read the films that he took. We can't review the questionnaires that Mr. Pitts filled out, the complaints that he made when he presented every 2 to 3 months when he treated with Mr. Ziegler over the course of several years leading up to the accident. We can't see what other doctors the chiropractor referred to him to. We can't see the records that other chiropractors in Mr. Ziegler's practice, how they treated him and those records. This is exactly the same type of evidence that the Chapman court says the spoliating party may not introduce. To allow it would put the plaintiff in this case in a better position than he would have been had he not spoliated the evidence, and it would create the same trial by ambush situation that the Chapman court cautioned about. And quite frankly, Judge, from a policy standpoint, it would encourage spoliation. Can you imagine, in some firms referring patients to the same chiropractors all the time, and some of them treated their clients before an accident? And if this were the rule, if the plaintiff were allowed to elicit testimony from the same chiropractor whose records the plaintiff himself concealed and therefore spoliated, then it would just open the door to widespread fraud. If there was no repercussion for spoliating evidence and a chiropractor whose records were spoliated could just fill in the gaps, it's just unfair. The second way that the plaintiff is trying to gain an advantage is through his own medical experts' causation opinions. Every one of the plaintiff's medical experts testified that they're able to link the conditions that they found in Mr. Pitts's complaints and alleged injuries following the underlying accident because of the absence of pre-accident records and evidence. And they all concede, Judge, their opinions hinge on the lack of that evidence that plaintiff spoliated. And they all agree that if that evidence, if there were evidence of prior treatment for his neck, his head, his back, elbow, that would affect their opinions. And there was never any effort to address that in reaching those opinions. Now, during these expert depositions, the plaintiff kind of brushed the adverse evidentiary presumption under the rug, and he deposed these witnesses as if there was no spoliation sanctions order, as if there was no adverse evidentiary presumption that the pre-accident records would have been adverse to him. They would have shown prior head issues. They would have shown prior neck issues. They would have shown prior back issues and all the other issues that chiropractors routinely treat their patients for. In eliciting these opinions, the plaintiff never asked the experts to do what the court mandated. That is, presume or even assume that there was prior chiropractic treatment, and assume that that prior chiropractic treatment would have shown treatment for the same issues that the plaintiff is alleged today. He has not laid the proper foundation to elicit that testimony. None of these experts were given the opportunity to acknowledge the evidence that is presumed by the court's spoliation sanction motion. And there's no testimony that within a reasonable degree of medical probability, given the prior chiropractic treatment, given the fact that the prior chiropractic records aren't available, and given the presumption that if preserved, they would have shown treatment and the same conditions that he's alleging today. There's no evidentiary, there's no foundation laid. Now, that evidence or those causation opinions could have been reached had there been other pre-accident records. Here, Judge, let me show you an MRI from before the accident that was taken. And it shows he had again, I use the term squeaky clean, cervical lumbar spine and no head issues. And here's a record from another medical provider he treated with around that same time. Based on that, And given the fact that the chiropractic records might have shown otherwise, can you still reach your opinion? Then the foundation's laid. But brushing all the court's order under the rug, you cannot get there with the testimony that the experts have given. And again, they all agreed that the prior treatment evidence would have affected their opinions. The plaintiff disregarded the court's presumption, and to allow the plaintiff to introduce that causation evidence would permit him to profit by this same spoliation. Now, in his response, the plaintiff argues, well, we can't prove our causation claims if we can't elicit the chiropractor's testimony and we can't introduce these improper opinions from his own doctors, these incomplete, equivocal opinions. Well, Judge, to that, I say that is the well-established risk of spoliating key evidence that could very well be harmful. This is the same situation, Judge, that arose in the Amley case, which we cited in our reply brief, and that's the Amley case is a 293 Georgia Appeal 3558. It's a 2008 opinion. In that case, the plaintiff, just like the plaintiff here, spoliated key causation evidence. And the plaintiff in that case, after the court entered its spoliation order, was unable to and did not introduce any proper evidence to rebut the presumption. Just as the plaintiff has, I'm sorry, did someone talk? Just as the plaintiff has not done here. And here the plaintiff has not presented any admissible evidence to rebut the presumption. Anything, no evidence certainly that, we can't refute because of the spoliation itself. That, Judge, as your Honor, I mean, litigation's it's like a jigsaw puzzle. We both say when we put the pieces together, it shows, a certain thing. The plaintiff might say, well, it shows, when you put all the pieces together, it shows one thing. The defendant might say, well, no, when you put all the pieces together, it's going to show another thing. Here's what the evidence is going to show. When a party spoliates evidence like this, they're hiding and throwing away the pieces. And the other side cannot show the court or the jury, this is what the pieces would show. And then under those circumstances, the party who throws away the jigsaw pieces can't be able to paint the picture and tell anyone what they would have showed, especially when the non-spoliating party hasn't had a chance to see those pieces. Now, again, we're not seeking summary judgment in our motion right now. We're asking the court simply and respectfully to apply its spoliation sanctions order to prevent evidence that the plaintiff has only been able to elicit because we have no opportunity to refute it because of the spoliation itself. The plaintiff, we respectfully submit, should not be permitted to profit from his spoliation, allowing this chiropractor's testimony and allowing these improper causation opinions that disregard the evidentiary presumption that the court imposed would do just that. And if the court's ruling on this motion prohibits the plaintiff from carrying his burden of proof as to causation, again, I'd respectfully submit, Judge, that's the risk of spoliating evidence, key evidence. That's my argument on that motion, Judge.
You want to be heard on any of your other motions, or you stand on your papers?
May I yield to my colleague on our other motions in limine, the ones that we have submitted, and most of them are standard, and I think that some of them are duplicates, and he might be able to go through them pretty quickly.
Attorney Lawley?
Thank you, Judge. Yeah, most of these
And
are.
if you don't need to be heard on them, don't talk just because you think I want to hear you speak. But if you want to be heard, I'm here to listen.
No, and I think there's really only one that we really need to be heard on, and it's the undisclosed witnesses, number one on our motions in limine.
Yes, sir.
In plaintiffs' proposed exhibits that he sent over to us, there was a what seems to be an expert report from a counselor or a therapist that Mr. Pitts had treated with and has been treating with since the accident. The report doesn't contain any medical or any records from any visits with this therapist, and this is a therapist that has never been disclosed to us, and we had never received this report before receiving the exhibits from plaintiff's counsel. I think speaking with plaintiff's counsel before, he told me that we had received it earlier. I don't have any record of that, so that's really the only one we would like or we would just ask the court to exclude that witness's report and prevent them from testifying.
Do you have the name of the witness?
It's Susan Sewell. She is listed on the plaintiff's portion of the consolidated pretrial order, but again, we had no idea of her. And there was no Rule 26 disclosure of this expert during discovery either.
Okay. All right.
Judge, we also have that fee schedule motion, but I don't want to, it's the same argument I gave. It's a separate motion and it overlaps with the plaintiff's motion to exclude the comp bills. So we don't need to go through that motion again unless the court wants to hear more about
I mean,
it.
I understood the arguments. Unless you got
Sure.
something else to say, I think I understand the arguments. Yes.
Okay.
All right. Any response from the plaintiff?
Yes, Your Honor. Your Honor, would you allow me to share my screen?
Yes.
Okay. Thank you, Your Honor. Your Honor, are you able to view the affidavit of Ann Cantrell on your screen?
Yes.
Okay. This was, as the court's aware, this is the affidavit of Ann Cantrell that was submitted with defendant's initial motion for spoliation. My issue with this, Your Honor, is that the entire motion is based on a document that is likely not admissible, Your Honor. We're going to argue that this should not be admitted in any way, shape, or form. I don't know. We don't intend to call Miss Ann Cantrell at the time of trial. And so I don't know how they're going to authenticate this. And also, this is a records custodian for a chiropractor's office who no longer works for that chiropractor, as Dr. Ziegler testified to. And this is certainly not a document that she would have made in the course of her normal business, Your Honor. Let's just go through it briefly. But my point is that this appears like defendants drafted this and sent it over to Miss Cantrell to sign. Here's Miss Ann Cantrell. She's over the age of 18. She was a records custodian in January of 2023. The last day of business was January 31st of 2023. So when they sold it, multiple thousands of charts were put into a storage facility. They were much more organized at the doctor's office, Your Honor. The past, I learned that the records for Jason Pitts addressed to, so this is a request that defendants sent to this chiropractor's office. I do want to make mention, I think it is a good time, that defendants and defense counsel have spent a lot of money trying to figure out what is in Mr. Pitts's prior medical history. I printed it all out yesterday. I think there's over 2,000 pages of records and requests, Your Honor. So they didn't leave any stone unturned when they were trying to find prior or alternative explanations to causation, Your Honor. And this is all they have, is an affidavit from Ms. Cantrell. Okay. So after I learned of this request, I began searching in the storage facility for Mr. Pitts's records. However, after a diligent search, I've been unable to locate them. Due to there being thousands and thousands of records in storage, I cannot confirm if Mr. Pitt's records are in the storage unit one way or the other. Now let that hold a little bit, Your Honor, because I believe defendants throughout this issue, starting with their original motion in Judge Morrison's court, have conveyed to the court that these records are destroyed, that it is an absolute that these records are destroyed. There is a possibility, number one, that the records still exist and they're sitting in that storage facility, but Ms. Cantrell opened the door, and this is not a part of her main job, opened the door, didn't see them, and then closed the door. I mean, we'd be willing to go look through the storage facility today, Your Honor, because I want to know what's in these records too, because I think they're going to show nothing. I think they're going to show exactly what Mr. Pitts has already testified to. I had no prior neck pain. I had no prior elbow pain. I did have low back pain from my job, but it usually resolved after a couple of chiropractor visits. And Dr. Ziegler confirms the same, Your Honor, from his recollection of Mr. Pitts. And this is not just some patient. If you'll listen to or look through Dr. Ziegler's testimony in his deposition, he's known Mr. Pitts's wife, Miss Margot Pitts, who is likely going to testify at trial. He's known her for a long time. And Mr. Pitts would just accompany her to her chiropractor appointments because she's got a bad back. And he remembered Jason because he's a U.S. Marine. He's built like Dr. Ziegler says he's built like a little bowling ball. And he's very matter of fact. Like, he's got a very good recollection of Jason. And so his testimony is valuable for the jury to consider. They say we destroyed it. I don't see any evidence in the record that the records were destroyed. Dr. Ziegler says they could have been destroyed. He thinks that he saw Mr. Pitts around 2015 or 2016. So with that timing and the records retention policy of the office at that time, the records could have been destroyed after 7 years, but that would have been before we actually filed this lawsuit, Your Honor. So the evidence in this case it's up in the air. And that's why we need a jury. That's why we need a finder of fact, because this goes to the weight of the evidence and not to the admissibility, Your Honor. So let me see. So that was why I started off, Your Honor, with the preamble of, I think that we need to get some clarification about this jury instruction, because I feel that a jury is going to be very confused when there's a jury instruction about destroying evidence that's based on an affidavit that is not admissible. We're not going to call her in our case in chief, or at least we don't expect to. And I haven't seen a subpoena, that defendants are going to call her to testify about. So I'm very wary about that jury instruction. It doesn't mean that I'm against it. I respect this this court's order wholeheartedly, and I want to work to make sure that we get an instruction that is not reversible. But I think that defendants are overstepping here. They're overstepping in their description of what happened with these records. They found no other prior medical records relating to his neck or his back or his elbow or his head. And so this is their last chance, Your Honor, and they're going to ride this into the ground. And then we'll just go back to the court's order, Your Honor. You created a rebuttable presumption. We have the opportunity to use that rebuttable presumption and to rebut that presumption. This issue really should be moot. The order has already survived my motion for reconsideration and my motion to vacate. So it wasn't for lack of effort on the plaintiff's part. But yeah, this issue should be moot at this point, Your Honor. And then I just wanted to talk about the Chapman case real quick, Your Honor. I don't know if you're familiar with the facts of that case, but that was a fire case, a large fire case where the plaintiff destroyed wires and electrical work that started the fire. We have a little bit of a different situation here, Your Honor. The records were never in plaintiff's control. If he treated with Dr. Ziegler 10 years ago, a couple of times for routine maintenance every couple of months, I just don't know how he would I can't get in the mindset of the plaintiff or a patient who goes into the doctor and says, I need to preserve these records just in case I'm involved in a lawsuit 10 years from now, Your Honor. So I understand that the discovery response was what it was, but the discovery response came on pretty recent to his deposition testimony, and he was fully honest in his deposition testimony. I don't think there was, I'd have to go back and look at the record, but I don't believe that there was like a large chunk of time in between his discovery responses and when he gave his deposition testimony. And this isn't a situation either where plaintiff responded to a question in the deposition, lied about it, and then kind of rehabbed himself. First, right off the bat, have you ever seen a chiropractor? Yes, Dr. Ziegler. I saw him a while back, a couple times, every couple of months. I had some routine maintenance is going to be the testimony, Your Honor. And that's, I think that transitions into they're also not only trying to get Dr. Ziegler excluded, but also the causation opinions of our treating providers. There's evidence on both sides, Your Honor. That's why we call it impeachment. If I on direct garner the testimony that this wreck caused plaintiff's injuries and symptoms and treatment therefrom, then their immediate impeachment is, well, you didn't have all the records. That's almost every single evidentiary deposition that I conduct of treating providers. You're attacking his credibility, but that doesn't make the causation opinions of his treating providers obsolete or in opposition of Georgia law, Your Honor. Here, I'll just read from Dr. Lynn's testimony. This is at page 58, lines 10 through 18. And this is me questioning Dr. Lynn. This is the surgeon who operated on Mr. Pitts' neck. Okay, I'll submit to you that in his deposition, he stated that he saw a chiropractor before the subject motor vehicle collision for general maintenance and not because of a specific injury. Are those records something that would have been vital to your treatment plan and care for this patient if he went to the chiropractor for general maintenance? Answer, no. So he just gave it to you. They've been asserting that I didn't lay any kind of foundation with his physicians, Your Honor. That was my redirect. I'm just reading straight from the transcript. Dr. Ruffin gives causation testimony for the elbow at page 27, line 12 through 25. Okay. There was a lot of alternative strategies during the course of this litigation that could have been taken by defense counsel. They could have filed a motion with the court prior to me deposing Dr. Ziegler. That coordination of the deposition happened over a handful of months. That deposition is now in evidence. He's been tendered. Well, no, I'm sorry. Dr. Ziegler is not an expert, so he hasn't been tendered, but I didn't see any objections to his testimony to that effect on the record. That's for evidentiary purposes. No objection was raised during that deposition. They could have taken Dr. Ziegler's deposition before or during filing the spoliation motion. That would have given them more information to this issue instead of proceeding head down towards the plan of motion for spoliation. We're going to get this order and therefore we win. No, let's dissect what's going on here. And that's what plaintiff wants to do. That's why we deposed Dr. Ziegler. We're not hiding the ball. We want to know all the facts so that the jury can know all the facts. And then just the one comment. I don't think this needs to be rebutted extensively, but this would encourage spoliation. I thought that was an interesting point of view. I would just assert, Your Honor, that would require a lot of perjury from a lot of people to put that plan into action. I'm not saying it's impossible, but this is a lot of people that are testifying under oath about this issue, and they don't take that lightly. I asked Dr. Ziegler about that during his deposition. And just that defense counsel has had an opportunity at all these depositions to cross-examine the witness, both for the treating physicians and for Dr. Ziegler. I think that's all I need to say about that issue, motion, what have you. The Susan Sewell letter. Let me get back to that. All right, Your Honor. We just went through a technology shift here at my office, Your Honor. So I'm still getting used to the way that we have to search for emails. I spent most of the day yesterday into the evening last night trying to look for an email where I sent this letter to opposing counsel. It's dated October 12th, 2024. And, this is just off my recollection. I remember sending it to Mr. Lawley immediately once we received it. But obviously I got to back that up. So, no harm, no foul. If we cannot find where we have done that, then we'll withdraw the letter, Your Honor. But I do think it's fair game that we allow Ms. Sewell to testify if that becomes part of our trial strategy. Mr. Pitts testified repeatedly in his deposition that he was experiencing depression and that he was seeking help for that. Let's see. And this is not really, I know they're trying to characterize Ms. Sewell as an expert witness, but she's a treating provider. The letter is certified, I will say that, but I'm not going back on my assertion that I will withdraw that letter if I cannot find my email to Mr. Lawley back in October of 2024. Yeah, I mean, the only reason that there aren't medical records accompanying the letter, Your Honor, too, I just wanted to respond to this briefly, is because that was Mr. Pitts and Mrs. Pitts going to marriage counseling, and then he shifted to individual visits with Miss Sewell after the crash happened. Obviously, in Georgia, I care deeply about our mental health privilege, and I want to make sure that my client's mental health privilege is protected. So that's why I don't think she keeps records, at least in the format that we're thinking of right now. But that's why there are no records accompanying the letter. And I think that's it, Your Honor.
Let me ask.
Judge? I'm sorry.
I guess a licensed practice. Miss Sewell, she's a counselor,
Yeah,
LPC
so.
licensed something counselor. Um, was she, other than the letter? I mean, I know you're looking to find the letter. Was there somewhere that she was disclosed as a potential witness?
Yes, in our pretrial order, Your Honor.
Okay, so there was the letter what you sent in October, and then again she was disclosed in a pretrial order.
She was disclosed in our pretrial order back when we were going to try this case in November, and I believe she was kept on there throughout our couple of renditions of the most current pretrial order, Your Honor.
Okay, understood. Thank you. Thank you. All right, very well. Yes, Attorney Horowitz.
Thank you, Judge. I'll try to be extraordinarily brief. It sounds like this is the second attempt by the plaintiff to seek reconsideration of the court's spoliation sanctions motion, and they're still challenging the order itself. I want to be very clear about this when it comes to the affidavit of Ann Cantrell, the records custodian. We are not seeking to admit that affidavit at trial, and we're not calling her as a fact witness at trial because, quite frankly, her testimony doesn't have anything to do with any issues relating to the trial. We elicited her, we got her affidavit because she was a records custodian to support our motion for spoliation sanctions. Her testimony and her affidavit, the value of that was simply to show that the chiropractor, Mr. Ziegler's records were kept until the end of, I want to say the end of January of 2023. And what Mr. Fluvog didn't read was the last sentence of that affidavit, essentially tying the knot that said, if we had gotten a request earlier, namely, if Mr. Pitts had responded to our interrogatory where we asked him to identify his chiropractors, and he did not simply identify a cardiologist he treated 7 years earlier, and and had he disclosed his chiropractor, we would have been able to get those records. Had the request come in before or right after Mr. Pitts responded to our interrogatories, we would have been able to get those records. And if that had happened, then we wouldn't be arguing this motion, Judge. But because Mr. Pitts concealed that evidence, we were, and whether the court looks at this through the lens of Rule 37, the concealment of evidence, which comes with the sanction of precluding, its same evidentiary presumption than if Mr. Pitts had burned the records himself, it doesn't matter. You get to the same place anyway. Either way, we were inhibited from getting the chiropractic records because Mr. Pitts concealed the identity of his treating chiropractor. Now, I could have sworn I heard Mr. Fluog saying that this chiropractor treated Mr. Pitts 10 years earlier. That's completely contrary. We cited Mr. Pitt's own deposition testimony where he said he was treating with that chiropractor in the 2 to 3 years before the accident, and including the year that the accident happened. Yes, we do our due diligence, Judge, when we defend these cases, and we serve non-party requests to any medical provider that the plaintiff identifies, because we want to make sure that we can obtain evidence. Just because we've served a lot of, non-party requests does not mean we're unable to find information. First of all, we have information about prior head, neck, and back issues. But the point, Judge, is that what is the best evidence of Mr. Pitt's pre-accident head, neck, and back conditions? Where would that come from? Would it come from his cardiologist, whose records we requested, 7 years before our accident, which could have identified it other providers, or from the chiropractor he was treating with up until the time of the accident? Mr. Fluvog referred to his examination of one of Mr. Pitts's doctors, Dr. Lynn, and he said, what if the prior records showed just general maintenance? Would that affect your opinion? And Dr. Lynn said, well, probably, maybe not. But that is relying on the same testimony that the chiropractor himself gave, that we cannot refute because we do not have the records. It again proves the same point that I've been making. The plaintiff is trying to profit from the fact that he did not disclose this chiropractor, and the fact he concealed his identity, and the fact that we now have no opportunity to look through those records. And we have an affidavit that had we gotten that information earlier, we could have gotten those records. Now, Mr. Ziegler can testify as to what treatment he gave and when he treated the plaintiff before our accident. But again, the best evidence of that would have been the records themselves. If he says he treated Mr. Pitts 20 years before, Mr. Pitts said he was getting chiropractic treatment up until the time of the accident, what's the best evidence? The best evidence are the records that he inhibited us from getting and spoliated. Now, just one last point. And again, this proves the same argument I made in my first the first time I talked about this issue, and that is the plaintiff is treating this case as if the adverse evidentiary presumption did not exist. The plaintiff is disregarding the entire scope and reach of the court's spoliation sanctions motion. Mr. Fluvog said we can impeach these medical experts in their depositions, just like he uses the term every other medical deposition. This, Judge, is not every case. And the medical depositions that he was taking in this case were governed by the court's ruling that they're imposing an adverse evidentiary presumption that the chiropractic records, if preserved, would have been harmful. That evidence, that presumption, was disregarded. It was brushed under the rug. And the plaintiff made no effort to lay an evidentiary foundation with his treating doctors, who all treated after and who all said that the prior evidence is significant to their opinions. He made no effort to lay a foundation in light of the presumption. He made no effort to identify to them any evidence that he elicited that could possibly be properly admitted in this case to rebut the presumption. As it stands now, Judge, that presumption has not been rebutted. There is no evidence to rebut the presumption. In any case, Judge, that's my argument. And as far as this other undisclosed expert, Judge, this mental health expert, again, as Mr. Lally pointed out, there was no Rule 26 disclosure in order to, introduce that evidence. They would have to identify her as an expert, the scope of her opinions, the evidence that was relied on in reaching that under 9/11/26. That's my argument, Judge. Thank you. And I know we've been going a long time, so I appreciate your indulgence.
All right, lawyers, thank you all. Thank you all. I've taken notes. I have your briefs. We will work this weekend to get you all an order before Monday. And I will reach out to Judge Brown in Gwinnett County to determine what order cases will be tried, and we'll let you all know that before Monday as well, so that everyone can go into the week knowing as much as we can know with an unexact science, what's going to happen next week. All right, Attorney Fluvuk, anything else?
Just one more thing, Your Honor, before we let you go. Are we permitted to ask any additional questions that were not included in our voir dire submitted to the judge, 3-4 months ago?
If you have some, get them to me. I know there was one motion Limine that objected to some questions. I would like the other side to see the questions. I would like to see them before they are asked of the jury. I hate to cut lawyers off doing their voir dire and tell jurors not to answer those questions. I would like to do that before the question is asked. So if get them to me, get them to the other side, so we can have a discussion about that before we begin jury selection.
Thank you, Your Honor. And just as we know it, we're scheduled to appear Monday morning at 9 a.m. and we do need to bring a court reporter, correct?
Yes, yep. You need to have a court reporter if you want one. Yes.
Thank you.
Anything else from the defense?
Judge, I had a chance to go through and look at the drafts of these consolidated pretrial orders. The first time that Ms. Sewell was included on a draft was on, I'm looking at January 16th, so last Thursday. And she was not identified before there. There's another expert on that one as well, who I forgot to mention during my oral argument, Shelley Weed of Weed Reconstruction and Expert Consulting. That was the first time that she was listed on their portion of the pretrial order. She has never been disclosed under Rule 26 either, and we would ask for her testimony to be excluded as well.
We're not going to call Ms. Weed.
Okay.
And I apologize for that. I had a different memory, but thank you for correcting me, Mr. Lally.
Okay. All right. Very well. Thank you all. Have a good day.
All right.
Thank you.
Thank you, Judge.
Bye-bye.